continued hearing. This is on the application of 61 Sheldon LLC and Edward O'Driscoll. It's dated May 10th, 2017, seeking either a special permit exception or variances from the terms of the Milton bylaw. The applicant is essentially proposing to build a single-family home on parcel 15B, which is adjacent to lot 51, which is at 61 Sheldon Street in Milton. The application alleges that lot 51 and lot 15B both contain more land area than most of the lots in the area, and so they're seeking a special exception to the special permit portion of the bylaw, if it's applicable, and if we rule it's not applicable, the applicant is looking for a variance. This case was originally heard on June 22nd, 2017, and there was a lot of issues relating to the title to the property. So we continued for a week in order to allow Marion McGettrick, the attorney for the applicant, to submit to the Board of Appeals a history and supplement regarding the lots and their status over a period of time, and her in support of her argument that this qualifies as a case for a special permit under Section 6A of the bylaw, or alternatively for a variance under Section 6A3. So on June 24th, Mrs. McGettrick submitted a very detailed memorandum, 4 pages, but with a lot of exhibits supporting her position. So we thank you, Mrs. McGettrick, for submitting that. And so we're here to discuss that and hopefully consider this application and vote on it. Let me do some preliminaries here. My name is John Leonard. I'm chairman of the Board of Appeals. To my immediate left is board member Jeffrey Mullen, and to my immediate right is board member Ted Daber. The rules are such that we'll hear from Mrs. McGettrick with respect to her submittal and hear any other additional evidence she wants to submit in support of the application. We'll also entertain questions if there's anybody present a member of the public who has questions or wants to speak in support of these applications or wishes to speak in opposition to the application. So without further ado, other than to indicate that we'll take Mrs. McGettrick's letter and her submittals dated June 24th as additional evidence in the case. Mrs. McGettrick, welcome back to the Board of Appeals. The floor is yours.
At the end of the hearing last week, there was some confusion, and you had inadequate evidence to show that the 2 lots in question here, or the 1 lot, which we're asking to create 2 lots from, were lots owned in common in 1938 when the zoning bylaw was adopted in Milton. And the reason that's important is because under Section 6A6 of the bylaws, in order to take advantage of Section 6A6, which allows for an exception for a less than conforming lot when a lot is owned in common in 1938, doesn't qualify for the exception for a house. A lot adjacent to a house lot, both of which are owned in common, but is a lot that might qualify for an exception because lots in that area are all less than less in area than the lots that are going to be proposed to be divided into separate lots here. And so it's very important that the lots have common ownership in order to qualify for the 6A6 exception. This doesn't necessarily relate to the variance argument, but it does relate to the special permit. So what I did was go back and gather together the information that I had researched previously. I made copies of probate records for you. I put it all together into a memo, and I'm just going to summarize, but I can answer questions if you have more detailed questions. So the basic situation is that there are two lots. One lot has a house on it, and there's a second lot which has remained undeveloped or basically a vacant lot. And beginning in approximately 1900, the Clark family acquired the first lot, which is the lot with the house on it. They built the house in 1903, and they occupied, first the father, William Clark, occupied the house with his wife. And by 1917, William Clark was deceased. His wife had died, and his three children, two sons and a daughter, had inherited one-third shares of the house with the lot with the house on it. One of the brothers who had inherited a one-third share, Robert Clark, that same year purchased the adjacent lot, which is the vacant lot. So starting in 1917, there was common ownership of the two lots through Robert Clark's one-third ownership of the lot with the house on it and his entire ownership of the adjacent lot. Between 1917 and 1961 at the Registry of Deeds, there were no records for these lots because evidently there were no changes of ownership. But what I did do was go back and look up the probate records for the estate of Mary Clark, the mother of the three children, who died in 1916 and willed the one-third share to each of her three children. And I determined from that there were three children, and I determined what the names of the children were who inherited the lots, and that one of them was Robert Clark, and that Robert Clark also had purchased the adjacent lot in 1917, the same year that probate estate was closed. I also went back to the Milton street lists, which are available in the town archives, just to see who lived at this address, beginning around 1915. And I continued to look at that through 1939, and I gave you examples of a few of those years. But in 1917, the two brothers lived at that address. The mother was recently deceased, and that's indicated on the street list. She died in 1916, according to the street list. In 1937, the two brothers and one brother's wife lived in the house at 61 Sheldon Street. And in 1938, the two brothers and the wife lived in the house, and then they list a daughter who became 21 years of age, and so then was first reported on the street list. The next record in the Registry of Deeds is in 1961, and this is a record conveying then common ownership of the two lots through a series of transactions from the daughter, whose name is on the street list in 1938, who then conveys to a trust, and then the trust which conveyed to the present owners. And in that 1961 deed, there are references to two probate records. One is Mary Clark's 1917 probate record, and the other one is Robert Clark's probate record, because at that point, Robert Clark had just died, his brother had inherited, and then his daughter inherited, because the brother also died. I went to the Milton Town Clerk's office to check the date of death for both Robert Clark and Herbert Clark, and Herbert Clark was the last of the children who died just that same year, 1961. So the reason there are no transactions between 1917 and 1961 are that these family members, Robert Clark evidently never married, all lived in the house for that whole time and continued to live in the house until this. Herbert Clark.
He married.
Robert Clark never married.
Right,
Herbert Clark was married.
right.
His wife inherited. He inherited from both. He inherited the single lot from Herbert Clark. Inherited the single lot from Robert Clark. So at that point, he owned all.
Robert Clark have a will?
Yes. That's the probate that's referenced in the 1961 deed.
In his will, he leaves it to his brother?
Yes. And you have actually a copy of the inventory from each will, and that shows that the only real estate owned was that lot and the one-third interest in the house lot. So that's, let's see. I should have numbered these if I was really doing this for a court, I would have, but it's approximately two-thirds of the way through these documents is a schedule of real estate in detail. I put Robert Clark, probate 159010 at the top left-hand corner. This is the schedule of real estate from the probate record, which indicates a one-third interest in a one-family frame dwelling, 61 Sheldon Street, valued at $8,000, and a parcel of vacant land on Sheldon Street, Milton, containing 10,060 square feet, $4,000 value. 10,060 appears to be an error because the lot area is actually 10,080. Every other record has, including the deeds, has 10,080 as the area of the lot. So that only addresses one aspect of this application, but it is an important aspect because if these lots weren't owned in common, then we wouldn't be talking about any of these exceptions. To qualify for either one, the house, two lots owned in common with a house on one of them, or this other exception where you can own the two lots in common, not qualify for the house exception, but still possibly qualify because the neighborhood has been developed with smaller lots than the two lots that you want to keep as separate lots. You wouldn't be able to take advantage of that if you couldn't show common ownership. The argument as far as the way the neighborhood is developed is, I provided some evidence of that in my original submission. I gave you, I made a little table up showing you the lot areas for all of the lots on Sheldon Street and all of the lots at the beginning of the Quincy part of Sheldon Street. So I'm just going to pull that out because I don't think we talked about it, and that's the other part of why I feel there is an argument to take advantage of this exception. I'd also say, although I haven't used this exception before, the building commissioner said that it has been used a couple of times. So this is not the first time that it would be applied to a situation like this one. Okay, I'm just looking. Sorry. You should have these. I certainly handed them out at the last meeting. I believe I have a copy here. It's just a two-page sheet with a list of all of the lots by number. You don't see it?
I have it, Mary.
Do you have
I
it?
do.
Okay, I'm sorry.
do, that's
I
all
may have
right.
given all the
Now,
copies to you.
let me see if it's the sheet you're looking for.
Thank you, that's exactly right. This is a memo dated June 22nd to the board, and I submitted it at the last meeting. I listed the house lots by address on the left side of the street, the right side of the street, and the way areas are listed by the assessors in Milton is in fractions of an acre. So the basic comparison is that the lots proposed, lot 51, which is the existing house lot, is .19302, or 8,408 square feet. The lot proposed as a buildable lot is .2435, or 10,609 square feet. If you look at the lot areas for the remaining lots on Sheldon Street, there's only one lot that is just slightly larger than lot 51, and that there are no lots that are as large as lot 15B, which would be the new house lot that's being proposed. There are a number that are .19183, which is quite close to 8,408 square feet on the right side of Sheldon Street. Then when you go into Quincy, the lots are all smaller, with the exception of one lot, which is .4677 square feet. That's lot ID 399. The lot numbers were not listed the same way in Quincy as they were in Milton. They're just assessors' identification numbers. So the basic requirement is that lots have generally been developed in the area that are the same or smaller than the lots that are being proposed in order to qualify for the possible application of 6A6. And my argument is that that is exactly what's happened in Sheldon Street. And most of the lots would be much smaller than the lots we'd be proposing. Area is the dimension that's talked about in the bylaw.
Great, have you completed your presentation?
I believe I have, yes.
Okay, great. You're going to send that two-page document back to us
Sorry.
at some point in time.
No, right now.
That'd be helpful. Thank you. Do you need a copy of that? We can give you a copy before
I have a
you-
copy on my computer. What happened, I think, was I didn't have time to make copies before the last meeting. I should have made more for this, but I didn't.
Thank you. Let me see if my colleagues have any questions. Mr. Jeffrey Mullen, please.
Marion, when you were introducing the topic, you gave us an alternative section, but then we really didn't speak to that. I know we're focused on A6.
For frontage.
What was the other section to which you referred?
It's the Section 6 part of the zoning bylaw, I don't know if you have the zoning bylaw there, that defines the frontage requirement of 75 square feet in a residency zone.
75 feet?
Yes. And so if you were not to do this under the 6A6 as the exception, and you were to look at whether to grant a variance, you'd be granting relief from the requirements of the frontage, from the frontage requirements for a residence C district, which
Yeah.
are 75 feet. These lots do not have 75 feet. One of them has 50 feet, the other one has 59 feet. And there are a number of other lots on Sheldon Street that also have frontages similar to that, but some of the lots have 75 feet.
Okay, so are you saying in your presentation that because Robert owned a third of the house lot and all of the vacant lot, that was the same as the same ownership in 1938?
He owned a one-divided, one-third interest, and I'm saying that is the same as common ownership. One reason I'm saying that is because of his ownership, you could not treat this as a separate lot. It would not have status as a buildable lot owned by a separate owner in 1938. It has to be one or the other. So there was common ownership. It wasn't exact identity. All the owners weren't the same, but I think it would qualify as common ownership.
So he never married.
He never married.
What were they like? Do you know what the Clarks were like?
No, I don't. They were a little bit older generation than me. I do know they were well-liked.
Good
and
question.
They were good neighbors.
Well, it may have some interesting aspects. I'm not sure it's
I can tell you this.
relevant to
This
our
is what I learned about the
inquiry here.
family. I learned that Robert Clark was a postal clerk from the time he was around 39 or 40 to the time, close to the time that he died. His brother was an accountant.
He lived there his whole life.
He lived there his whole life with his brother and his brother's wife. His brother was an accountant, and he seemed to have a little bit more management of the family affairs. But who's to know? I mean, I
Well,
couldn't
his
tell
sister
for sure.
conveyed her interest to him, not to him and her.
In
him and his brother.
1917, the sister
That was
conveyed
his favorite
hers.
brother.
Oh, they had, or the brother paid the sister for the interest. You know, it wasn't, the amount isn't named in the deed, so. So it was one or the other. The brother may have had more resources and been able to pay for the sister's interest, but she wasn't going to live in the house. Evidently, she was was married to someone else. So that's what happened. And the family must have remained comfortable with each other, and they remained all residents of that house for the whole time they owned it.
Right. Now, there was testimony the last time that the vacant lot was really part of the house lot. There's actually a structure on the vacant lot that goes with the house lot.
There was a garage built in 1920. The garage structure itself was built prior to the zoning bylaw and has status as a structure on the lot, is whatever. From the building perspective, the building inspector's analysis is that were it not for the fact that they have too much area, they would have qualified for the exception under the adjacent lots with a house on it.
Unless it merged.
That's his analysis. I mean, I have, I might have a different theory about
Yeah,
that.
yeah.
But this is the building inspector's determination. However, because of the large area, they don't qualify anyway, so we didn't go beyond that.
When was the neighborhood generally developed?
Generally, well, there are a number of Victorians that were built very early, like the 1903 house that we're dealing with here, but there are many houses that were developed in the 1920s and the 1930s. The Quincy houses, some of them look much more recent.
When the bylaw refers to, in section 6A6 says, adjoining areas have been, comma, prior to that time, comma, is prior to that time referring to 1938 or prior to the time of the application for relief, do you think?
I think it means prior to 1938.
Yeah.
That's how I would read it.
But in this case, the neighborhood was developed prior to that time, meaning prior to 1938.
It was. I don't have the date for every single house, but
Yeah.
there are many houses in the street that were built before that time.
Do you know if there's any evidence that the Clarks always considered that to be separate lots?
I can tell you that they continued to convey using the separate lot descriptions, the separate deed references, and the separate plan reference. If we had a situation.
And you
where
said
we-
they got a separate tax bill. You said the lots were always separately taxed.
There's one, I looked through all the assessor's records, these are pretty old, and there's a couple of times when the assessors thought about combining them, and there's a note, and the note is, it retains the separate identification number, I guess.
In
is the
fact,
way
they
to put it.
must have had 3 tax parcels, right? 1 in Quincy and 2 in Milton.
Yeah, they did,
Yeah.
they did have a very small sliver
Yeah.
in Quincy. That, by the way, I mean, assessor's records are not legally, you can't rely on assessor's records as proof. But it is an indication that the family was attempting to retain the separate identities. I believe that the brother probably, when he first purchased the lot, thought that he might someday build a house on it, but he never married, and he just continued to live with his family. And then that didn't happen. When you look at cases about, mergers, and you already raised the issue, you have to look at whether the separate lot description has been retained or whether the lot owner has started to use a lot description for the entire lot. They didn't do that here. So that would be one indication that they intended at least to have them continue to be separate lots. But when it's one family owning them for the whole time, it's really hard to say for sure.
Right.
They were just there.
Right. Yeah, my sense is they probably didn't give it a whole lot of thought, so. Okay, that's it for now. I have another
Mr.
question
Haber.
after Ted finishes, I'm sure.
I guess the first part, I did do some research, but I did it this afternoon, and I spent a little bit of the time while you were talking, going through some of the parts of the cases, and I apologize if I missed it. Did you spend, I know you mentioned it in your letter that you submitted earlier this week, but have you talked about the variance argument tonight?
I haven't talked about it too much tonight. I did in my original memorandum, and I can certainly
Right.
talk about it again.
Could you speak- is it
Yeah,
okay?
my argument on the variance would be, it's always difficult, of course, to find a very good legal basis for a variance, because a variance is supposed to be related to what the lot is like, the physical characteristics of the lot. There are 2 things I would say about these lots. They're much larger than lots in the neighborhood generally, and they slope up towards the rear. So their topography is a little bit unusual. It's a reason why they've remained large, but it's not any reason, it's not a reason why this lot has to be 4 times as large as most lots in the neighborhood. The other argument I would make is that it doesn't really make a lot of sense to keep, I guess this is more of a common sense argument, but to have such a large lot in this particular neighborhood, which is 1 street away from the Southeast Expressway, where housing values are very good as they are throughout Milton, but reflect the fact that this location has some burdens, which is that it's so close to the expressway, that under these circumstances, that it makes good sense to allow there to be 2 lots that are similar to other lots in the neighborhood. It reflects a good value for the land. If you leave this lot as the extra large lot that it is currently, it's not likely that you're going to retain the value that you might if this lot were in one of the best and most expensive neighborhoods in Milton. In that case, the argument would be, why would you want to change it? Why, it's going to have a great value as a single house with a really large lot around it. But in this particular neighborhood, I don't think you're going to ever recover the value of the extra large lot. You're still going to have a large lot, one that's generous with a very good backyard. And it's more in keeping with the characteristics of the neighborhood that the two lots be allowed rather than have to leave it as one. The topography argument is simply that these lots both, if you were to stand in front of them, you would see the backyard goes up at a fairly steep angle in each lot. They need to be, they can be larger. You're not going to be building a house in back because of that topography. I'm not asking for permission to do that, but there's no reason why you can't divide the lots in two and have two houses with a generous area for each house to be located.
All right. Part of the reason I asked was because on the special permit argument, I did some research on common ownership under Section 6 of Chapter 40A, and found a few cases which bear on it. I mean, nothing on point, but some cases which do bear on the question of common ownership. And the first one, I don't know whether you looked at these cases, but the first one is Planning Board of Norwell versus Serena. It's an SJC case. And in that case, the question of common ownership had to do with two landowners, husband and wife, owning one lot as tenants by the entirety, and owning the other lot in a trust of which they were the sole trustees and the sole beneficiaries. And the court held in that case that it was common ownership, and they said, it was a rescript opinion, said that the judge below had determined that all of the land in each of the Serena's two lots was available to avoid or reduce the dimensional nonconformity of either lot viewed in isolation. So the appeal, the SJC affirmed and basically said that a landowner will not be permitted to create a dimensional nonconformity if he could have used his adjoining land to avoid or diminish the nonconformity. And that's
kind of the usual rule, yeah.
That's what the
Right.
court held in that case. Okay. So the second case that I've had some other cases, but I don't think there is necessarily as pertinent, but was Marinelli versus the Board of Appeals of Stoughton, which is another SJC case from 2003. And it's just a definition for purposes of this case of what they said lots in common ownership means. For purposes of Section 6, lots are, quote, held in common ownership, end quote, if they are listed as owned by the same party on the most recent instrument of record prior to the effective date of the zoning change, which is basically what, but that still, to a certain extent, begs the question, to what extent does the same party have to hold title? And in the first case, it was the same two people owning 100% of the title with control over the property. The first case that I cited, the Serena case, has been basically interpreted, I think it was in this Ruprecht case, which is a land court case, as saying that really one of the key issues is control. You know, they won't, and that to a certain extent has to do with disallowing, you know, the checkerboarding cases to to
Yeah.
avoid the merger doctrine.
Right.
Because, the idea is that the people who owned it really were in cahoots and could still control what happened on the other lots. So this case of William Ruprecht versus the city of Pittsfield was a question of where there was an undeveloped property that was held in joint tenancy by a mother and son, and an adjacent residential lot held by the same mother as a life tenant, with the son holding a remainder interest. And the land court in that case, and it was a 2010 case, held that the properties were not under common control, and therefore were not under common ownership.
And they aren't. Well, the mother isn't as a life tenant.
Well, no, but
Yeah.
the point was
Right.
that so long as she alive, Mary, who was the mother, controls the one lot as a life tenant. Contrastingly, Mary and her son have joint control over the locus as joint tenants. As such, the locus and the Cummings Avenue property are not only separate legal ownership, but also under separate control. In light of the above, I found that the locus and so she held that was not, the judge in that case held that it was not common ownership. And to me, looking at these cases, and I'd like to hear what your thoughts on it, the idea that, was it Robert Clark owned one of the lots in the entirety and a 1/3 interest in the other lot, who controlled the other lot? Was it his sister who owned 2/3? Is that, or was it at the very least in common control with the sister, as was the case where the husband and wife were joint tenants, and the court said that in that case it was common control, and therefore was not common ownership for purposes of the statute.
Well,
So that's, and I like I said, there may be other cases out there, but these cases throw, in my mind, shed some doubt on the common ownership, on this having been common ownership as of 1938.
Okay, I understand, and I am generally familiar with those cases, and I'm aware that that's an issue. And I guess the argument that I would make is that the lot with the house on it, lot 51, was owned as an undivided 1/3 interest by each brother and the sister until the sister conveyed her interest to Herbert. So then it was undivided 2/3, 1/3 interest. It was all by will, and that's how the will described their interest. So what do you do in a situation like that, if you want to separate the interests? What usually happens is you go back to probate court and you get a determination by the court, and the court has to approve a settlement, essentially, or an agreement as to how the lot can be conveyed, and who's going to have what legal interest in the lot for the purposes of conveyance. Until you do that, you can't convey by yourself. It's not the same, there are plenty of cases I've seen and plenty of histories of lots I've seen here in Milton where there was just exactly that sort of probate court decision. It's always accompanied by a recorded plan that shows after the decision who's going to own which part, so that they then have legal title and they can convey by themselves, and they don't have to agree together on what they're going to do with the lot. So my analysis would be that in that situation, they have a common interest, and that it is an ownership in common. But the other thing that bothers me, and I'll go back to some other ways of looking at this as well, that bothers me about this is, well, so the argument you might be making is that in that case then, the lot that the owners want to develop now was not held in common, was not owned in common. Therefore, it was a separate lot in 1938, and it could have been conveyed at that time and for many years thereafter as a separate lot, but then by inheritance, when one of the brothers inherited this interest, the two lots merged. And that, the theory then would be that destroys the separate, they then become merged at that point, even though they weren't merged before. So we would have a problem now because they would be merged. So if you want to take the viewpoint that in 1938 they weren't owned in common, then you would have been able to develop that separate lot, but then that would have been defeated by the inheritance in 1961. And I really didn't have time to research that. I haven't seen a case on that, but there may be cases that determine whether or not merger definitely occurs if you inherit, whether that you lose your separate status or ability to develop the lot. And I think you do, but I don't have a case to suggest. I just want to point one other thing out to you, though, as far as analyzing these lots go, and maybe it goes to the variance argument more than to this argument, but the problem with our bylaw is that we have this provision that says, in order to take advantage of the house lot issue, if these were owned in common, you have to have less than the required frontage, less than the required area. And that provision doesn't really make any sense, because the purpose of such a provision is to force somebody who has the ability to make his lot legal by combining some part of the adjacent lot to do so, or at least to force you to put the excess area with your deficient adjacent lot. And these two lots both have non-conforming frontage, so you can't take frontage from one lot to make the other lot conforming. There's no way you can apply the bylaw that really makes sense, but it is what it is, it says what it says, and you have to follow it. So it's just kind of an anomaly in the way it's written. So that's kind of a side comment. As far as your argument goes,
It's not,
I think
by
you
the
can
way,
argue it either way,
right,
really.
It's not an argument.
I mean,
I'm
it's-
just-
I know you're
it's
using
just
the
cases that I'm reading that I,
Right.
have to bring up because they
Right.
bear on the subject.
They do,
yeah.
and I understand that, and I see that, well, it is an argument, I think. I mean, you could take those cases and try to say these lots were not merged, and I would argue that they are merged, because they had one-third undivided interests together in the house lot. One of them couldn't sell the house lot without the others agreeing to it.
Well, tenancy
And-
by the entirety case, each of them had an undivided one-half interest in the lots, in the one lot, and then the mother, I think it was, owned the other lot in the entirety, so they had undivided interest too. So, I see what you're saying, but
It's interesting, because these are usually applied to prove that one lot is buildable because it's a separate lot. Here we have the reverse situation, so.
I know.
I just.
It is unusual. But
Well, I guess I would conclude without really being able to say for sure. I mean, you may be right about that. That's a good analysis. Those cases exist. I'm certainly aware of them. I still believe there is an argument for a variance here. I don't think there's any harm, given the nature of the development patterns in the neighborhood, the fact that the neighborhood and the neighbors support this proposal. I think there's no substantial detriment to the neighborhood, and I think there are some characteristics that make these lots unique because of their size and because of their topography. So I would say there is an argument for a variance if you don't feel comfortable with applying the bylaw. And I guess I'd pretty much rest my case on that.
I don't have any more questions right now.
Okay, well, I really need your help, Mary, and I need the help of my colleagues, because I have to tell you, it's an abstract area of the law for me. I'm not a conveyancer. Mr. Mullen, in his younger days, was a title examiner. And I've never examined.
Last week.
I've never examined a title in my life. I have difficulty finding the registry of deeds. So I look at this a little differently. I look at, not in the smaller picture, but at the big picture. So I appreciated the materials that you sent. And the first thing I did is I looked at the deed. And when I saw the deed certainly makes two conveyances. But, and I noticed Mark Murphy, was he the lawyer for the buyer? Do you know?
Yes.
He was, okay.
I think so.
Great. And in this quitclaim deed, Miss Leonardo, as trustee of the trust, conveys to 61 Sheldon Street LLC the two lots. But when I looked at the first lot, the description of the first lot says a certain piece or parcel of land located at Milton. And I said, that's kind of strange, because the second lot says a certain parcel of land in Milton. So it seemed to me that somebody, maybe the lawyer for Miss Leonardo, was somewhat concerned as to the status of that first parcel. Is it a parcel or is it a piece of land? And when I saw this, I see that the applicant here paid $550,000 for these two lots. And I said to myself, well, wow, I mean, were the representations made as to these lots? What did the purchase and sale agreement say regarding these lots? Was this discussed? Is that the reason the lot number one, I'll call it, is talked about as a certain piece of land rather than a parcel of land? And what really concerned me more than anything was whether the applicant here paid a lot of money believing that the first lot was indeed a developable lot. And all of a sudden he finds that he needs a special permit or he needs a variance. Because I know a lot of times in these cases, sometimes the buyer doesn't have an attorney with Marion skills, and they kind of rely on maybe common knowledge and all of that. So
I'd like to point out to you, first of all, that in 1917, the exact same description, piece of parcel, was used to describe this
Well,
lot. That is not a change, that is just the way the lot is, the parcel is described.
So-
So single parcel, when it was conveyed, was described exactly that way.
So my concern was whether the applicant put himself or put itself in a very awkward position by paying a lot of money for I'll call them two lots, only to find out at the end of the day when he talks to the building inspector that he needs relief to build a house.
Well, I think the applicant has been looking at this lot, this land, before he bought it, as to its potential, but didn't have any guarantee that there would be two separate lots when he purchased it. I know that because he's been working with me for a couple of years researching it. I will say this to you, I mean, on my street, I live on the other side of Milton in a neighborhood that is probably not as elegant as this one. It's a nice neighborhood, but the lots are 4,000 to 5,000 square feet, and the house 5 doors down from me just sold for $560,000. And it's not as big or as nice as the house on this lot. So I'm not sure that the price necessarily indicates that this was two lots
No,
in
it's just a
value.
factor to be considered. But what I did then is I went to the assessor's records, and I agree with you. The assessor's records are not, I guess, legally binding as to whether merger has taken place. But when you look at the assessor's record, in effect, prior to the time that the applicant bought this property, it's listed as one lot. It's listed as one parcel that contains 0.424 acres of land. And there's a picture of the house, and there's a picture of the lot. It doesn't have dimensions. And so when you multiply out that, it's the 18,469 square feet that was purchased. It was both lots.
Right. I'm not arguing that it's a legal
And-
separate lot.
No, just let me finish.
That's
I
okay,
want to
yeah.
get questions. So when I look at it then, I said, well, what was it assessed for? And it was assessed for $513,600. So what the applicant did here is he purchased a single lot, at least under the Milton assessor's records,
Yeah.
that was assessed for $513,000. He purchased it for, I believe it's $570,000, $550,000. And then is now seeking to come before the board and say, well, wait a second, I didn't buy one lot, I really bought two lots because I want to develop this second lot. And I want to build a house on that lot. Even though he paid allegedly fair market value for the property when he bought it as one lot. And so my concern, and I want my colleagues' help here, and yours obviously, is as the Board of Appeals under these circumstances, if there's a substantial likelihood that these lots have merged, number one, I don't know how we get out of the merger situation. You'd probably have to file some application to subdivide the lots. I don't know that. We don't do that. We don't allow subdivisions of land. And my bigger concern is, what precedent does this stand for? Are we going to have people who buy property in smaller areas, lot areas, but they buy a big lot, coming before us and saying, well, I've got more than the lot area required for each lot, even though I bought one parcel of land, and now I want to develop this vacant half of the lot or portion of the lot into a house lot so I can basically double my deal. And I can remember some cases, though I can't cite chapter and verse, where people tried to do this very, very thing by having a 20,000 square foot lot or a 40,000 square foot lot, and basically wanted, and the house was fortuitously sited more towards one side of the lot than the other, and then they want to come before us and essentially subdivide the property and double their investment. And I can remember we're denying those applications. So I guess my question is to you, is that what's happening here? And what kind of a precedent do we set? Not only in this section of Milton, which has very small lots, but in other sections of Milton where there are larger lots, where we may be faced with 10 or 15 applications, maybe not as contemporaneous as this, but where somebody purchased far much more land than required under zoning, and now wants to subdivide the lots. I can actually remember down by Turner's Pond, I forget that section of Milton, it's, you know the streets down there. There's a classic street down there, it's like Linsdale Lane or something like that.
Hinkley Road.
No, it's not Hinkley. No. It's down by Turner's Pond,
Yeah, Hinkley Road.
on the right-hand side. And
Depends on which way you're going.
well, it does. But, and I can remember a couple coming before us with an application I thought very similar to this, where they basically had their house on one side of the lot, they wanted to sell the other as a separate buildable lot, and we turned them down. So can you tell me, if we bought into your arguments, which are sophisticated and skilled, I think you've made a wonderful presentation of a case that may be bordering on the impossible, but if we accept your arguments, what type of precedent does this cause for the board?
Well, this isn't a case of a single lot where somebody's just decided to subdivide it even though they don't have the required frontage for two separate lots. I mean, it didn't arise that way. I understand what you're saying. There could be a situation like that, and I'm not trying to establish a precedent where anybody can come in and say, well, look, I've got a lot of land here, but it happens that I don't have very much frontage, but I think you should grant me a variance anyway because the lots would be larger than required, even though the frontage wouldn't be conforming, and that's just the end of it, and that's my argument. Here we actually have
The applicant's a builder here, and the applicant studied the lots, presumably knew, at least according to the town records, that this was one lot and not considered two lots.
No, we didn't know that, actually, when we originally looked at it. There's still some question about the application of the Milton zoning bylaw, about the merger of a house, an adjacent house with a lot with a house on it. I did go to the building inspector again and discuss it with him. I've looked at that over the years, because it's questionable whether their bylaw makes sense the way it's written, and a court could interpret it to say the only way that makes sense is it's only if you have enough frontage on the adjacent lot to make the other lot more conforming that this bylaw makes any sense. And otherwise, it should be applied so that if the lot has less than the required area, less than the required frontage, or one or the other of those, that there's no merger. But I'm not approaching this lot from that perspective. I'm approaching it from 6A6. My argument under 6A6 is that the lots were owned in common in 1938. I know that you've heard an argument that, or you've heard some cases that might seem to indicate that that's incorrect, and if you choose to follow those cases and apply them that way, then my argument is defeated. But my argument is based on 6A6. It's not based simply on, let's just go and apply a variance to a single lot. There is a lot description that has been precisely the same since these lots were first acquired, which is in approximately 1900 for one of them and 1917 for the other one. Separate lot descriptions, a separate vacant lot, and a lot with a house on it. It's always been the same through every transaction that's taken place. So with that history, I thought, I agree with the owners when they purchased the lot, and we had some meetings with the building inspector who felt that 6A6 applied. Now, he may be wrong, you may disagree with him. That's why we're here, because we've studied this together, and it was his feeling that this ought to, this qualified, that this was similar to another case that had occurred, I don't know what the case was, but where the board had applied 6A6. However, you have this issue with whether it's common ownership or not. You need to look at that. I'm trying to make the variance argument based on the fact that because of all these factors, there's a pretty good argument that they were either separate lots that didn't, if they merged at all, they merged only because of the happenstance of an inheritance that put them into common ownership in 1961, or that you should apply 6A6, that they were lots owned in common in 1938. And the exception applies, and it was designed for exactly the situation, that you have these two lots, they don't quite qualify for the lot with the house next door, which is what the main exception is in the Milton zoning bylaw, but they do appear to qualify for the other exception, which says that neighboring lots are all much smaller. They are not characteristically the size of these lots, especially the lots when they're taken together. They're much, much larger than any of the lots in this neighborhood, and that they should be allowed to be developed as separate lots. It's not a usual type of situation. I don't,
Can I ask?
but it would be a precedent of a sort.
You know
if you
whether the
apply it.
purchase and sale agreement said anything about whether the lot was buildable or not, or
I don't know, I wasn't involved in that, I'd ask the owner.
I think it did.
didn't?
And-
Because that's what I can't imagine, why if the property is fairly assessed, I don't know whether it is or it isn't. It was considered one lot, assessed for $513,000, and you buy it for $550,000. Sounds to me like you bought a house lot with a house on it.
May I give you some information?
Well, yes, but
about
I
the
don't think
assessors,
the-
about the assessors' information?
Sure.
Because the assessors' information was.
Oh, you have to come up here.
Yeah. What you're looking at may very well be the corrected assessor's information, because until I pointed out the mistakes to the assessor's office, that they were actually assessing the lot my memory is not,
What it used to
because this
be.
happened a few months ago, a number of months ago, but when I looked at the title and I looked at the assessment and I went to town hall and I spoke to the building inspector and I spoke to I can't remember the name of the head of the assessor that's down there.
We won't hold that against you.
So they were assessing it incorrectly. And and I'm trying to remember exactly what that incorrect way of assessing it was, but they were assessing the lot that the house sits on as almost the full value and assessing the land at some minor value that had an assessment of like $300 or $400. So I'm assuming that since I brought that to their attention, and they said that, oh yeah, this is incorrect, we're gonna have to change this, and we're gonna have to redo this, that they may have actually done that. So the assessment that you're now looking at, because they were not assessing it as one lot, they were assessing it at two lots, only the other lot had a minimal amount of assessment on it, like $300 or $400.
Yeah, but this card that I have in front of me shows that Marjorie Clark and Janet Leonardo were are the owners of the property. They assess the land value. Whoops, I'm sorry. Where did Marion go? Okay, well, why don't we
Sure.
wait a couple of seconds?
Sorry.
No, that's all right. I looked and
Give me a
all of a
drink of
sudden
water.
you're gone.
I apologize.
That's all right. You all set?
Yeah, I am, thank you.
Okay, great. This property assessment card shows that the value of the land is $306,600, and the building value is only $199,900. So for a total of $513,000. I don't know what it's based upon, but I was just surprised. I actually, what I wanted to do was to make sure that the buyer and the buyer's representatives didn't end up paying $700,000 or $800,000 for this property, thinking that they had another buildable lot and they would make money on the buildable lot.
But they paid $550 for it.
Well, that's what I mean. The whole thing is that both lots are assessed for $513,000. You paid $550 for it, not you, but the LLC paid $550 for. So you bought full value according to the assessors, and I don't know any more than
And
that.
the value of the house that sits on the lot in a finished state is probably closer to $800,000.
I don't know that. It says $199,000.
Well, no, but, Mr. O'Driscoll is renovating the other house, and it's, and there are, brokers coming by to look at it, et cetera, and they're putting a price tag of close to $800,000 on it. So, I mean, it's not, he didn't really go into the project saying, oh yeah, I'm gonna get to build another house over here, but simply saying, there's a potential to make a good profit for the amount of work I put into this house and refashioning it in a way that it brings top dollar. And that was the speculation, and that's what's proving to be the reality, actually.
No, I hear you, but that's where I am. Mr. Mullen, do you have anything to say about this?
This is a good one.
Well, it is a good one.
So I think the reason that the 1917 deed says it's a part of a parcel is the parcel is in Milton Inn in Quincy. And I think it's got something to do with that. In terms of the only relief,
You know what, let me do this. Okay. Marion, do you have anything else you'd like to add?
No, I don't think so. I think I've pretty
Okay,
much
well,
said what I
I do-
can
I
here,
do
and
too.
I realize there are some complexities to
Okay,
this
then
case.
let me do
I
this,
recognize that.
just to clean up the plate, and then we can start to talk about it.
Okay.
Is there anybody present this evening who wishes to ask questions of Mrs. McGettrick or the landowner? And there's no such person present. Is there anybody present this evening who wishes to speak in support of these applications for relief? And there's no such person present. Is there anyone present who wishes to speak in opposition to these applications for alternative forms of relief? And there's no such person present. So unless anyone has anything further.
Can I make one more?
Of course you can.
Yeah, I
Mr.
was
Dale.
just looking at 6A6 again, and I just want to point out, and see if you have any comment on that. This too, and the same language is used in 6A6 and 6A3. It doesn't use the term common ownership,
Right.
which I didn't realize before. It says,
That's right.
are recorded as all in the same ownership at the time this bylaw is adopted. Which to me is, even stronger than common ownership. I mean, I think it's harder to argue same ownership.
Yes, although I think I agree, but I think it's meant to say the same thing, and I understand what you're saying, and,
Okay.
I think, yeah, I mean, I guess it depends on how you want to look at it, for this case and for Milton.
That's it for me.
Okay, thank you. So what we'll do is let's end the evidence portion of the hearing, and we'll see if we can have some reasoned discussion about these things and see where we go. Mr. Mullen, do you want to be heard?
The only relief that you're seeking here, because really what 686 speaks to is not so much a special permit, but it's discussing the relief that's being sought. It's really frontage, right? In other words, to the extent that a building gets built on here, you intend, or the owner intends to comply with all of the setbacks and all of the height requirements in the bylaw. Okay. So we're really talking about the varying, or this term that this section uses is the special exception. Making a special exception, quoting the bylaw, under this section due to a finding that, as Ted just said, the lots were in the same ownership at the time the bylaw was adopted and therefore didn't merge. That's really what and then having to find that one of these secondary conditions, more specifically, the adjoining owners have been, prior to that time, meaning prior to 1938, developed to a substantial extent by the construction of houses on lots generally smaller than is prescribed by this section, and the standard of neighborhood so established do not reasonably require subdivision of the applicant's land until lots is large. That's what we're speaking to. Okay. So the reason we're here is Lillian Bishop didn't have the good fortune to convey her 1/3 interest to her brother, Robert, and instead conveyed it to Herbert, and that was a fatal, perhaps not fatal, but had Lillian known in 1917 that we would be sitting here literally 100 years later speaking about this, she had probably moved away. She was the daughter who moved away while Robert and Herbert stayed in the family. I mean, it's a great Clark family story, right? Which is what makes this also terribly interesting. So I was going to point out that it's not so much about common ownership, it's really about same ownership. And the Section 6, 48 Section 6 cases are trying to establish the reverse of what we're really going to, right? We're trying to establish whether or not it was indeed the same ownership in 1938. Because if it were the same ownership in 1938, then there wouldn't be merger, and there wouldn't be a reliance of one lot trying to solve the nonconformity on another lot, and therefore you'd be able to take exceptions. So I looked at the Muir v. Wisconsin case, actually, which came down this week by the Supreme Court. And I actually think it might be helpful here, because it's about the expectation. That case talks about a regulatory taking in Wisconsin. And the Supreme Court is trying to lay out an expectation. What are the reasons? What's really happening here? Did the Clark family think in 1903, when William Clark was doing his thing, built the house in 1903, in 1901 there was a conveyance, or in 1917, or in 1961, or when it got more sophisticated in the records, did they really think that they had a separate lot there? Is I think what this case is about. And I would urge the board to really think about that, because there's been a lot of testimony, kind of on both sides. I can see both sides of this. But I do think the Supreme Court is telling us that the reasonable expectations of the parties that were involved in setting up these lots. Oh, and by the way, I don't think the assessor's records is particularly helpful in establishing a lot, under the bylaw at least, because the bylaw defines a lot to be on a recorded plan, although it does indicate same ownership. So I think John's revelation makes this more muddy than we would want. So I'd urge us to discuss, and on the one hand, it was the side lot for the house, and the parties treated it as if it was their yard. It was not a separate. There was some physical characteristics language in Muir v. Wisconsin that may be helpful as well. And don't get me wrong, the fact pattern is completely different. I'm just using the language, and it was a merger case, because ultimately it was about whether or not there was a regulatory taking. And it's so new that perhaps it's new doctrine that will ultimately find its way down to this august body. I don't know. While I see the variance request, I don't know that we would be prepared tonight to rule on it because I'm concerned about what that really means for both lots. Because in order to grant a variance on one, you need to know more about the other. And so I'd urge us to take a little bit of a deeper look at 6A6 and think about same ownership, not in a technical sense of tenants by the entirety or joint tenancy, but more about a common control and what was happening with Herbert and his brother Robert, and whether or not they reasonably expected that the lot was indeed a separate lot for all those years. That's what I would say right now, anyway. I don't know if that helps at all, John, but
Oh, I think it
those are
does.
some
Ted,
things
what do
that
you
I
have
had
to
on
say?
my mind.
This is like a law school exam.
It is.
question.
Yeah, it's good. Yeah.
Bar exam
Yeah.
question or something, I don't know. I mean, I did the research this afternoon on these cases, and the mass cases, and they, they do talk about control. They don't distinguish between situations where the ownership is set up by probate as opposed to deed. I mean, I see what you're saying there, but I didn't see any cases in what I looked at that, distinguishes them. I just see the words, same ownership in these sections, and that the parcels were not in same ownership. And I look at these cases, and I'm not sure how we, as a Board of Appeals, get around those cases by, finding other reasons not to go along with what they say. Because to me, same ownership, maybe it does mean the same thing, but if it does, then I think it strengthens what otherwise might be a murky, a more ambiguous term, common ownership. So I really don't see how we get to 6A6 based on what I read, and I guess I agree on the variance. I think you're right. If the parcels did merge after that because they were in common ownership despite the deeds, under the merger doctrine, then there would need to be some kind of a
Subdivision.
yeah.
Yeah. Yeah, we'd have to establish the frontage on both lots. And then you might have area issues, I don't know. It's more tricky than we'd like it to be.
Right.
Yeah.
Right, but I'm interested to hear what
Yeah.
everyone has to say about it, because it's a blazing new areas for me, that's for sure. Attorney Leonard?
Well, my view of this is that I tend to think there was a merger here, but I can't tell you I'm a great real estate lawyer to make that decision. I don't think this is a variance case under any circumstances, but I understand Marion's argument, and it's a persuasive argument in a sense, but if there was a merger, as a matter of law, wouldn't the applicant have to go to the planning board to try to subdivide it? And we don't have the power to do that.
No, that's what I'm saying.
And
It might be an A&R plan, I don't know, I have to,
Excuse me, you would have to grant a variance, and the planning board would have to approve the subdivision, because the planning board won't approve a subdivision. I'm not saying that that's what you're gonna do anyway, but the planning board won't grant, requires that any zoning relief be granted prior to their approving a subdivision. That's what our rules and regulations in Milton say. So the truth is, you'd have to do both. You would actually have to decide that you would qualify for a variance and on what the basis for that would be and grant it. And then we would have to go to the planning board, and they could still decide that they didn't want to allow the subdivision, although, yeah, they could, actually. They're two different sets of criteria, and the planning board in some instances has done that, and that it produces, it's not going to hear, I don't think, but it can produce litigation and all kinds of things. It's an interesting situation, but it happens.
But regardless, the point, I think,
But that
is
isn't really-
we're not prepared to act on a variance because we don't know the facts regarding it, which was what we've
Yeah,
also
I mean, these two lots are the same in the sense that they're the same size. They both have the slant, they both are long lots, and that's it. I mean, those are the characteristics of the lots. If you think that they might qualify for a variance, that would be one thing. If you don't, our argument primarily was resting on 6A6. It was resting on the belief that the real situation for this family was that in 1917, they lived together, and prior to that, they lived together in this house. Robert chose to buy the adjacent lot. He continued to own it. He continued to live in the house. I don't know exactly what the arrangements were among the family, but they had, I assume, some kind of reciprocal arrangements. Robert wrote his will early, and in his will, he left his lot to his brother. But he didn't, convey it to his brother outright. He didn't create, strictly speaking, common ownership in the sense that the title to both lots was the same. But it's pretty close, because there would have been that expectation after a lifetime of living together and a will that was going to give the land with the house, 1/3 interest as well as the lot to the remaining brother, that they were in it together, that they did own it together, and they weren't going to do anything separately. So that's
Can I ask you a question, Marion?
Sure.
And it's this. We're not judges in the Superior Court or the Land Court.
should be.
And under these circumstances, I really feel very uncomfortable with this, despite your hard work and your diligence and your integrity, and I mean that sincerely.
Thank you.
Since we're not in the land court, maybe that's where you should be? Why wouldn't proper procedure here be for you to withdraw this application without prejudice, and to file a declaratory judgment action in the land court? And where you'd have a judicial determination of what your rights are.
It would be an option.
And then you'd be getting something that's definitive. Sure, it's an expensive option in a
And a
sense.
lengthy one. Land court takes years.
Well, I don't know how long you've been in the land court, but the judges in the land court these days are exceptionally quick.
Well,
Year and a half, it's not 5 years or anything like that. And they're experts in this area of the law, and they're certainly objective. And then you'd have the ability to protect your rights in the event you disagreed with the judge. Or if you got a decision in your favor, then you've resolved your issues. I mean, is there something fatally wrong with that? As opposed to us pretending we're scholars of the law of merger and same ownership or common ownership. I think, personally speaking, Ted and Jeff Mullen are really good real estate lawyers. I stay away from real estate except when somebody takes it by eminent domain. And then the question is value. So it seems to me that you may be asking us to do something that may be beyond the normal scope of our duties in the Board of Appeals. Jeffrey, what do you have to say about that?
Well, you heard what I said. I want to read. I think you got a pretty unique fact pattern. I'm not as concerned about the precedent, but I can sense the uncomfortableness of my colleagues, and the tradition of this board has been to offer to the applicant the opportunity to withdraw and reconsider the argument. And if that's where this is going. I don't want to force a decision that is the wrong one, I'd say that. But I also wouldn't immediately foreclose the possibility that this may very well be an appropriate variance case based upon the testimony regarding the size of the lots and the general character of the neighborhood. And the fact that you've got large lots that happen to not have a whole lot of frontage. So that's all I'd say right now.
Mr. Deba.
I agree with what Jeff said about the, the variance aspect of it. Yeah, I do feel, based upon the cases I've read, that I would not feel comfortable granting a relief under 6A6. For the reasons I've, discussed, not to beat a dead horse. And also some of the arguments you raised as well. If there was a merger, then, I guess the procedure would be, again, you go to the planning board, but you have to get a variance first, you said.
Yeah.
So, I can't, based upon what I've read and seen, and recognizing, obviously, that, the happenstance, as you termed it, of somebody passing away, and obviously nobody knowing that this zoning was going to come into effect, but that's what the zoning ordinances do. They come into effect and they set deadlines, and people are kind of stuck, at that point, with what the zoning law says. And except to the extent that the zoning law specifically, makes exceptions. And it can't cover everything. So I guess that's my thought as well.
Well, Mrs. McGettrick, why don't I ask you this?
Yeah.
Do you want to take 2 or 3 minutes and talk to your
I would like
clients
to
in
talk,
private?
just ask them maybe what their preference
And-
would be. I appreciate if you're not, you don't have the votes, really, it sounds like, you can correct me if I'm wrong, but it doesn't sound like you're in agreement as to variance, and you're certainly not in agreement as to 6A6 at this point. So I would like to go back and discuss whether.
Sure, why don't we
want
take
to
4 or
withdraw
5 minutes and then...
Yeah,
I'd like to
can we ask a question, if you don't
about
mind?
the variance aspect of the case. So,
Is that appropriate, or?
Well,
Should we
Well, I
discuss
can-
it?
we'll talk to Mrs. McGettrick.
Let's talk
and
together, and then we'll come back
That's
if
the
we
better
have
way
a
to do
question.
it.
Probably heard the whole conversation.
That's
but,
all right, no, we didn't. We were
So
we were
we're,
chatting about the good old days.
The applicants they're in a fairly difficult position, because however, I understand right now, I'm not hearing that there are 3 members of the board who are comfortable with granting a variance. I'm not hearing that there are 3 members of the board who are comfortable with granting under 6A6. I think the best option is to ask if we can withdraw without prejudice, which means that we could return to the Board of Appeals with another application for a variance or some sort, if we felt we had a better argument that we could put forward at that time. If you're offering that option, I think that's probably the best one. I will say that it's a difficult situation in that they've renovated the house, they're getting ready to sell it. They have it, I think, under some kind of agreement, but right now they can't sell it because the lot they thought they might be able to sell it is not a lot. You can't divide this lot, you can't, there's no description that's legal that they can record they'd have to work that out. So there's certainly some things that they need to address. It's not the board's problem, but I'm just explaining the reality of the situation and why we're sitting in the back of the room trying to figure out exactly what the best thing to do is. So as I see it, my advice to them to the owner is that this isn't the best option that you can offer, is to allow us to withdraw without prejudice. If that's what you're saying we can do, then I think perhaps that's what we would like to do at this point. Unless you change your mind and you
No,
want to grant one of those.
That is what you want to do.
Yes,
Okay,
unless you,
sure.
See it
Mr.
differently.
Bowen, do you want to be heard? Mr. David, you want to be heard? Okay, so all those in favor of allowing the applicants to withdraw without prejudice their application for a special exception or a special permit pursuant to Section 6 of Section 6A, and alternatively for a variance from the terms of Section 6A3 of the Milton zoning bylaw, please say aye. Aye.
Okay, thank
So
you.
your motion's granted. We'll do a little quick decision and sign it and file it, and thank you for all your hard work.
Yeah, thank you for your careful consideration and discussion, very interesting. We'll be doing a little more work on this and see if we can do more with it.
Okay, great.
Thank you.
Thank you very much. Sure. Do you want to, you're going to write a quickie? Yeah. Yes. We're adjourned.